Hello, everybody. So, welcome to Wealth, Wills, and Trusts. Before we get started, I wanted to have a little question out here for everyone. One in the chat, if you wish you had a time machine to go buy Google or Amazon stock right when they became available, good God, I always think of, if I could tell my 15-year-old self, 18-year-old self, 21-year-old self, all these things, right? We want to be able to use time machines to fix the boo-boos, the opportunities that we missed. But that's one of my big ones. Oh, if I had a time machine, definitely buying some Google stock. Okay, so who am I? Why do I do this? I'm an attorney. I've been practicing now about 17 years. I'm also a mom. I'm a business owner, but most importantly, I witness the outcome of people not planning. I see this because I handle litigation. I handle probate litigation. I handle disputes between family members after they've received an asset through a deed. I handle all of that. And so that's why a big part of my practice involves preventing that chaos. I don't like that chaos. I don't like that chaos for you. I don't like that chaos for the people on the other side. And so my goal is to go out there and educate the public about how to prevent this, because it is preventable. That's the positive side. In this webinar, right, we're going to have a lot of interaction. I want you to really come away with this having a good understanding of what is estate planning, what are the risks, what you can do to get involved, and what are all the options out there for you, because I am going to talk about all the different options. But very importantly, if you have questions, please put them in the chat. Okay, this is for you. This is your opportunity to ask a lawyer questions. Granted, again, I'm going to answer in generalities because I'm not your legal counsel and we're not a confidential meeting, but it is an opportunity to speak with a lawyer for free about maybe things that have been just itching at the back of your mind. All right, so let's get started. Who benefits from estate planning? Anybody. Okay, anybody who has something worth protecting. It could be that you have minor kids, but maybe you're just at the stage where you're renting. Well, you need to protect your children. It could be that you own a business, maybe by yourself, maybe with some siblings, but you definitely have something at risk if something happens to any one of you. If you're married, if you're single, if you're part of a blended family, if you are currently in that sandwich stage where you're taking care of your parents and taking care of teenagers, this is important because it's not just about, for example, your minors. It's about the people that are dependent on you. So as the first part of this webinar, I wanted you to have an opportunity to verify how prepared you are. A lot of people come into estate planning thinking, oh, I need a will, that's all I need. But the reality is you need to understand preparation and the real things that will affect you to find those gaps. And to know, I need to address this part and this part. So let's get to it. We have a couple of exercises that we're going to be having you do. Julie is going to be putting into our chat a little link so that you can fill out your answers privately. It's confidential. They're all yours to these little practice questions that we have. All right, so exercise number 1, we're going to talk about incapacitation. And why? Because there are too many times where people think of estate planning only as dying. But estate planning also has to address your incapacitation, because the longer we live, the higher the chances that we're going to be dependent on somebody else to help us with our finances, to help us make healthcare decisions. So that's why we're asking these questions. Okay, so number 1, would you know who would be the one caring for you if you were in a coma tomorrow, right? Who would be the one caring for you? Sometimes we think, oh, it would absolutely be my spouse. Other times we're like, well, you know what? I think my sister with the big fat mouth is going to raise her hand and she's going to want to be involved and she's going to want to be in control of everything. The reality is that sometimes people raise their hands that we do not want involved, but unless we have a legal way of barring their involvement, they have just as much say as our parents, as our spouses, as our children. So that's a reality I want you to understand. Would they know where your assets are? Okay. If you are incapacitated, you need to be taken care of. It costs money, right? It costs time. It costs money. If people don't know where your assets are, it's going to be very difficult to start taking care of you. But you don't stop being incapacitated. There's no pause button on you where you're like, oh yeah, I'll wait until you find my things. No. So people not knowing where your assets are, or you not having that organized for the people that you want to take care of you, is a big risk. Okay. You also have to ask yourself, do they know what your needs are with your doctors? Do they know your allergies? Do they know your healthcare diagnoses? Do you know what medication you can't take because it's going to affect some other part of, what you're experiencing? If they don't know how to do that, if they don't even know who your primary care provider is, they're going to have a very difficult time making sure you get the best healthcare as an incapacitated person. Okay. And finally, if you haven't designated somebody with the capacity, with the authority, or given them all this knowledge, would they even have the money, okay, to step up, to file what needs to be filed in court to get that authority? If the answer to any one of these is no, you've got gaps, okay? Exercise number 2. What if something happened to you tonight? For those of you that have young children, or maybe that have elderly parents that you take care of at home, or that depend on you, even if they're in a memory care facility or skilled nursing facility, right? So who watches over your children or elderly parents when you're working late? When, they have an illness, let's say a parent in a skilled nursing facility, who is the person in charge? And if something happened to you, if you went missing, if they couldn't find you, who would they call? Usually that call is 911. So 911, if they don't have a list of people to quickly identify, to get a hold of, 911 is going to take your children and put them with foster safety people, especially if they have no idea who your trusted family members are. Or they're going to take your beloved elderly loved ones under the care of Adult Protective Services. They can't leave them on their own. Do you want that to be the case? Or would you prefer that the people that you designated be the ones that act? And then the other part of it is, even if you know who you'd like to step in to get custody of your children, or to now take over the role of, primary caregiver, care watcher for your elderly parents, do they know what the values are that you have in this, especially with raising your children? Do they have access to your finances to support your children or support your elderly parents? Without access to these tools and resources, it becomes incredibly expensive, and it takes a very long time to be able to put the people in place and give them the kind of authority necessary to take care of children and other dependents. All right, exercise number 3, and this is the last exercise in this particular activity. What would happen the day after you die? Okay, so we're talking about death now. And again, who do you think is going to step up to handle things? Because it's not always who you think. Sometimes the first person to open up a probate is actually a creditor. Sometimes the assets are so poorly known that they go missing, and then probate has to be reopened years later when they're like, oh, and there was this other thing and this other thing, because there was no organized way of knowing where things were. And for some of you who might be in, greater wealth accumulation stages, if you've made certain gifts during your lifetime, those probably need to be accounted for. But if you don't have anything demonstrating what you gifted to A, to B, to C, you are going to create a very expensive gift and estate tax return. The other aspect is sometimes we have family members that don't even know all of the related people. Okay, I have had daughters come in and they're like, my father passed away. I know that he had another family. I have half siblings. I don't talk to them. I don't even know all of their names. That is a big challenge. This is information that is absolutely necessary because guess what? Probate court will make you file an affidavit of heirs. You have to swear under oath that these are all of the people that might have an interest in your estate. And then, of course, do the people that you'd like to be there have the money to hire a lawyer and open probate? Because your assets, they're frozen, okay? They are frozen. So with that in mind, let's get into it, okay? Let's get into some more of the education. I want you to avoid this, okay? I don't like seeing this. This is litigation. This is probate. It opens it up to this. I've been in probate proceedings where, an ex-wife at the last minute created a fun little power of attorney and like completely emptied out the bank accounts of the person, retitled the truck, like there's real serious litigation disputes in court. I've also seen it where because of the tragic events of how somebody passed, there is severe friction between blended family members. And so without a plan, people end up like that. I like having families really stay out of court. And why? Because I want those family relationships that you have that are working to be preserved, okay? And I also don't want the ones that have a little bit of friction or a little bit of difficulty to get any worse. You don't want things to be worse. You want them to be pleasant. You want people to remember you as the one that had their act together and minimize that conflict when everybody is already mourning you. And that is a very difficult thing in and of itself. All right, so let's talk about some planning mistakes that I've seen, okay? So number one, deeds, okay? Sometimes people go, oh, I think it'll be really easy to just add my son to title with me. And so when I die, great, they'll get everything. They'll get this house. Well, you've just reduced your homestead tax deduction by adding somebody to the title with you immediately. It's also a gift, so it triggers gift tax return requirements under federal law. Why? Because, well, half of a house is worth more than $19,000. Yeah. Also, well, you've opened up yourself to your child's creditors because that's not necessarily their homestead. And so their creditor can go after your property to satisfy their claim. So these are just some of the things in having a joint tenancy with right of survivorship deed, okay? Life estate deeds, yeah, even ladybird deeds. One of the biggest problems that I've seen with ladybird deeds is people think, oh, great, like it's gonna pass over to brother and sister after mom dies, and mom still has the right to maybe like mortgage or refinance, but they totally forgot about mom becoming incapacitated. That thing is now fixed in stone. And what if you needed to do something with her home in order to pay for her care? You're stuck. You have no rights, okay? Other times people say, well, I have a trust and I'm going to make my son the beneficiary and I'm going to make him the only trustee. It's going to be so easy, except now your son's lost creditor protection. Yeah, these are the little nuances that people don't know when they make those cheap planning mistakes. Okay, so I want you to be aware that these are not always the best tools and they're more of a last resort than a proper planning. All right, so remember, we don't have time machines. Okay, I absolutely love the Back to the Future trilogy. I'm a total nerd when it comes to that, but I don't have a DeLorean. None of us have a DeLorean. None of us can go back in time to fix a mess, which means when we do something, we should strive our best to do it in the best manner possible while we're here, while we can actually control the terms, while we can actually control who gets involved, while we know what our assets are. This is so important. I want you to get that deep down. There is no DeLorean. You can't travel back in time. You can't undo it. One of the problematic aspects of improper planning, and this isn't because people don't care, okay? You care for your loved ones. You absolutely care for your loved ones. You want the best for them. But when you don't plan, often these loved ones who you would have hoped your assets went to do not have the money to open up probate administration, don't have the money to open up guardianship administration. But the very problematic aspect of your assets being frozen is they can't use them to pay for doing the transfers. And so those assets just kind of get lost, okay? These are involuntary taxes. They can escheat to the state of Florida, okay, and any other state where you had assets. And now that's, hey, you paid a giant tax donation to the state because your family could not get a hold of that asset. In Florida, there's at least $2 billion worth of assets that are stuck that way right now. And nationwide, $70 billion stuck because probate is far too expensive. So now that I'm, you have an understanding of some of the weaknesses, right, in cheap plans, of the tools that people try to use, well-meaning, but not understanding the real consequences. I want you to give yourself another opportunity to see how much of your legacy you're putting at risk right now, okay? Because there is a high likelihood that you're missing at least one critical piece. Even if you have a plan right now, there's an opportunity here for you to look through what you have and see, how can I make this better? How can I cover these gaps? Okay, because these are preventable problems so long as you are alive, because we don't have time machines. So the next slide is going to give you a little QR code to take the legacy leak test. Okay, it is a very quick 15 question test, yes, to determine what leaks you have and whether you're probably somebody that's going to have to consider redoing a plan or actually doing a plan. You don't have to answer the questions right now. It's just take the QR code, because this is an opportunity to have not only a resource to see your gaps, but also to talk to your loved one, to talk to your spouse, to talk to your significant other, to talk to your siblings, to talk to mom or dad about the gaps that you've been seeing, about what you've been noticing, but having like a professional tool that tells you, ooh, these are problematic. These are things we need to address. So the QR code is there. I believe Julie has also put a link in the chat if, for example, you're watching this from your phone, so that you can get access to that QR code and that legacy leak test. Okay, so if you take it and you go, oh my God, I have some serious things to address, then your next step can be a private legacy planning session with me. Okay, not everybody qualifies, and that's okay. There are plenty of other attorneys that can assist different families that specialize in little niches, right? Lawyers are like doctors. We're doctors of law. But for example, you don't go to a neurologist to deal with your heart. You go to a cardiologist. You don't go to a podiatrist to deal with your lungs, right? You go to a pulmonologist. So this is why it's important to understand, hey, I need to figure out which firm might best suit my needs, right? Maybe because I'm over the age of 75, maybe because I have a special needs child. These are all different reasons why you might need specialized attorneys, and that's okay. But for us, we always start out with a legacy planning session for our clients. It's personalized and we go deep. This is a 90-minute meeting with me. So if you're interested, if your score is telling you, hey, you might need some real assistance, and you qualify, because, hey, we're also going to see if you're a good fit for us, then we have this opportunity for you. It's a golden ticket for a free phone call. It's a discovery call to see if we're the right fit for each other. There's no pressure there, okay? Great. If you qualify, beautiful. My team will let you know what's involved. If you don't qualify and you've given my team kind of an idea of what your needs are, we usually have people that we can refer you to that are specialists in that particular area. But we definitely don't want to leave you hanging, thinking, oh God, there's no one that can help me. No, there is most certainly somebody that can help you. This is for you to be able to reach out to us, to book a discovery call to see if we're a good fit. But now we're moving along to continuing teaching. Okay. Oh, and yes, we want you to have clarity. All right. This is very important. Because without clarity, you end up being one of those people that make the mistakes that add somebody to title with you, that fail to take into account many, many things and think, oh yeah, this labor date is enough. Those kinds of things. I don't want you making those mistakes. Okay, so what are the planning options out there for people? Well, number one, the Florida statutes, that's the default plan. You don't have to do anything to get that default plan. We're going to talk about how it works. There's also, you can download online forms or use a non-lawyer. Sometimes the financial planners are and insurance agents are providing forms for you. They're not great. We're going to talk about the issues. There's also door lawyers. That means they'll take anything that walks through their door. There's high volume firms, so there are estate planning firms, but they rely on having a very high volume of people that come through their door to do very basic plans. Big law, those are the pricey ones, and then our planning. So we're going to talk about all those options. Okay, so the estate plan. What happens if you become incapacitated? Number one, it is not automatic that wife or husband or daughter, if you're not married or whatever, are going to be the default person legally allowed to do everything. That is not the case, okay? Even if you're married, sorry, you can't go and access your spouse's bank accounts to manage financials. If that's their account or that's their investment thing or that's their retirement, you can't touch it. You will need to go to probate court. And if there's disputes, right, this person wants this and it's mom, this person wants this and it's husband, and they're not in agreement, the doctors are stuck. They can't do A or B. It's that Terry Schiavo issue. And to remind you all, the Terry Schiavo problem of her having been incapacitated and mom and dad wanting something different from her husband was 15 years of litigation. 15 years. Okay. So next, it's a court proceeding, okay? It's done through the probate court and a subcourt called guardianship. And then there, you're going to need your lawyer. You're going to need, the guardian's going to need their lawyer, the one who wants to be a guardian. There need to be 3 court-appointed specialists to determine the level of incapacitation you have. And you're going to need an accountant to help you comply with the accounting requirements of the court. That is at least 6 professional fees. I say at least 5 because sometimes instead of it being a lawyer for the person who is incapacitated, sometimes it's like an ad litem, and depending on the level, it might not be as much as regular professional fees. But the problem is, once you're at that stage, there is no control, okay? It takes months to set this up because the priority for the courts isn't you, isn't your well-being. It's, are the assets at immediate risk of being lost? That's it. That's the only thing under the statute that makes it a rush case. Not are you okay? Not are you going to suffer catastrophic health consequences? Are your assets okay? So I want you to understand that because the probate incapacitation system isn't healthy. One of the other aspects you need to be mindful of is that in court, you might get a judge that just happens to rub the wrong way on the person who's petitioning, and that judge is going to make it really frustrating to get anything done. Sometimes you have a judge who is wonderful and understands the case and understands the need of your loved one, and boom, they get assigned to a different thing. A new judge comes in, you have to reteach everything, and they might not be as a great fit for the guardianship as the old one. There's also no caps at all on costs or fees. These things can take hundreds of thousands of dollars like that. You lose your rights if you are a ward in incapacitation proceedings. You can't vote, You can't drive. You can't even petition for government assistance on your own. Everything has to be done through a guardian. And anyone who's a close relative or a Florida resident 18 and over can raise their hand to become your guardian. Yeah, your neighbor can raise their hand. So the exposure and vulnerability resulting from the state's plan is something that I always recommend you try your darnest to avoid. Here's a true story. Okay, I've changed a little bit of the information, so of course you can't identify who my client is, but my clients had some trouble finding their child a couple of years ago, and their child had not done any planning. There was no power of attorney, no health care, nothing in place, right? And this was an adult, so it's not like they had authority to do anything for them. They had to open up a guardianship proceeding and sue to get the rights to become the guardians of their child. It took months. And the first, I think like 3 months or so, they told me they spent $35,000 in legal fees just for the appointment. Then I had to follow up with them, and it took $20,000 for just 1 year of acting as their child's guardian. So that's 55 grand in a very short period of time. Okay, that's more than like a person's average annual salary here in the state of Florida. It's painful. It's painful. So one of the other things I want you to take away, other than this is very expensive to go with a state plan, is ignoring the fact that things can happen to you when you're young is not a good approach. Okay, incapacitation is not just, oh, I've got dementia or Alzheimer's when I'm 83. No, it could be that you've developed an addiction issue. Sometimes we get given pain medication and don't know how we're going to react to it, right? It could be that we suffer a horrible car accident that affects our memory. These are things that can happen to us no matter the age. Okay, no matter the age. All right, so let's talk about the state plan relating to when you die. That's called probate administration. And in Florida, if you pass away with a will or with no will, you have to probate the assets, meaning you have to pass them along through the court process. There's no escaping it. It's not like the people you see on TV holding a big thing saying, "And to you, Charles, I leave my blood." No, that's not how it works in real life, okay? Probate is public. Probate is intensely slow, okay? People are not used to how slow the court system is. I'm here to tell you that it could take 1.5 years, 3 years or more to probate assets because there's all these little nuances, and creditors get first dibs. The first job of a person who gets appointed as an executor or person representative in an estate is to go and get the creditors notice and to deal with all of the claims. And until all of that is done, they can't even consider making a single distribution to any one of the heirs. Okay, so there's no creditor protection there. The legal fees are also quite large. If you have a $1 million estate, okay, you have a $500,000 house, you've got some retirement accounts and investment accounts that were left over. That easily gets to $1 million. It can be 6% of that. Easily, a judge will be like, this totally reasonable fee, okay? All right, so 60 grand, absolutely reasonable fee. But the problem also becomes that people don't have the cash to pay that hourly $60,000 fee. So sometimes they have to go to a contingency lawyer, a lawyer who will let you they'll be your bank, but they'll charge quite a bit to be your bank. So contingency fees can range anywhere between 30 and 40%, depending on the level of people arguing in the case. That is extremely expensive. That goes from being 60 grand to $300,000 or $400,000 in a $1 million estate. Okay, so I also want to introduce you to the bond. In probate proceedings, judges do not want people that are appointed to be like, I can do whatever I want because now I've been appointed the manager of all these assets. No, they have to be really, really careful. They don't want you flying off with people's assets and money. So they make you pay what's called a bond. I'm going to give you an example of bond payments that have been required in a couple of recent probate proceedings that I've had to do. So in one, the estate is probably worth like $250,000 total. That one, the judge very nicely just required an $18,000 bond. Okay. There's about $1 million estate that somebody's handling, where every single one of the people involved were like, yeah, I want you to be the one to do it. That one was about $150,000 as a bond. And then in another one, the only person who is like an available child of the person that passed away, in about, again, another $1 million or so estate, probably even less than $1 million on this one. That one had to pay $275,000 as a bond to be able to act. And this is why probate is so cost prohibitive and why people can't do it. So relying on a will is absolutely terrible, because guess what? Judges don't care if the will says, and please no bond. That $150,000 one, yeah, the will contained that language. Please don't make them pay a bond. Judges can ignore that every single day. Okay, so that was the state's plan. Let's talk about online forms. Okay, I'm gonna briefly bring this reality to you. I have been practicing law for 17 years. Okay, in those 2 decades, I have never in my life seen an online form that didn't have problems, and I'm talking real problems. I've had people come to me that said, Natalia, look over this trust, etc. And I'm like, no, your loved one did not create a trust. This is a will. I've had people come and say, oh, like we have this in place, and what can we do? And can we just get it addressed really easily because this has been created? To which I have to say, oh, did you know that you as the surviving spouse, because of the way this is drafted, receive nothing? There's a lot of problems in these online forms because you're not getting legal advice, okay? You are not being told the consequences of choosing A or B or how they have to be executed or any of that. And I'm going to tell you another recent story. This is a real story. Again, facts kind of changed to keep protection, but very caring son. He downloaded something online. It was a trust for his mom. They thought, great, we'll have a trust. It'll be easy. We'll avoid probate proceedings. And the way that it was drafted, it kind of worked well enough while she was alive. She set up some accounts in the name of the trust and all of it, except that the trust failed to have the requirements for it to be a testamentary trust, meaning something that can work after you die. And so the trust ceased to exist upon the moment of her death, which means that they had to rely on something completely different and had to open up probate. And they've incurred quite a bit in probate fees. This is the problem with relying on online forms. People that are not attorneys, that don't suffer the consequences of committing malpractice, that don't have an errors and omission insurance, that don't have continuing education requirements, are not going to properly advise you on the use of online forms or the forms that their financial advisor company has given you. Okay, they're not going to give you the proper advice because they can't. It's called the unlicensed practice of law. So another lesson for you from a lawyer: fixing is always more expensive. And this is the truth, whether you open up a case and you thought, oh, I'll just open it up on my own, and then you realize, oh, this is a horrible mess, I don't know what I'm doing, and then you go get an attorney. It's going to cost you at least 3 times more to get it fixed. And the same thing goes for improper planning. If you didn't have legal counsel help you with that instrument that created a contractual arrangement, it's going to be so much more expensive to fix it in court. All right, so next option that we have is door lawyers. So as I mentioned, door lawyers is a term that we attorneys use in our industry to say an attorney that will take anything that walks through the door, right? They generally do personal injury, they do some business law, they do some traffic tickets, they do some criminal law things, sometimes they do some family law proceedings, but they literally have specialization in nothing. They have like surface touching of all of these different areas, including estate planning, but they don't know any of the depth. They don't know any of the big end consequences. They most definitely do not know any of the tax planning, because I've seen the work produced by door lawyers and it's not great. Okay. This will get you a set of documents, but nothing more. And those documents, there's no guarantee that they're going to work. High volume lawyers, okay? High volume lawyers are the ones that are, let's say they're estate planning firms, or they do estate planning and probate. Usually they do estate planning and probate. So they'll create these documents for you, okay? And they'll do them quickly. But the problem is, because of the speed that they're required to do and how many files that they're required to do, because they charge less for estate plans than boutique firms or big law firms, mistakes get made. Or they do them in such a basic way that it's essentially preparing your family to go to probate proceedings, because they're relying on the much more expensive probate to actually cover the costs to keep the lights on. So high volume lawyers, you get lots of tired associates working on these things for you. They don't really have a lot of conversations with you about how to select the best people, or navigating family dynamics, or dealing or addressing with any tax issues or special needs or blended families, businesses. And they also don't help fund. So if somebody creates a trust for you in a high volume firm, I can guarantee you they are not going to assist you in the proper connection of all of your assets to the trust. I call them $2,500 paperweights. Some are more than that, but on average, $2,500 paperweights. Big law, okay, big law will do all the things, okay? They're going to help you select all the best people. They're going to help you navigate those dynamics and deal with vulnerable individuals and deal with tax landmines. They're very good at tax landmines. They're going to help you plan for blended families and business succession, but it is going to cost you a pretty penny, because they charge hourly, okay? And to get the big law partner, the one that has the real deep knowledge, it costs, let's say, from $600 to over $1,000 an hour, okay? If you are not getting the big partner, you're going to get an associate, but that associate's still going to have to charge like $400 to $500 an hour to work on this plan for you. And again, those can be baby lawyers. They can have 1, 2, 3 years of experience, but because they work for big law, they have to charge those hourly rates. The most frustrating thing that I've seen from the big law firms that create plans, that the plans are good themselves, it's just that they do no funding, okay? They do not help their clients actually transfer assets into the big, beautiful instruments that they're creating. And so these are empty, very, very, very expensive paperweights. I had a client come to me that paid, they paid $8,000, which isn't a huge big law number, but it was something reasonable to say, like, hey, I deserve some quality. So this client has a lot of mortgages out there, because they're kind of like a private lender, and buildings and so forth, millions and millions of dollars worth of assets. Not a single one had been connected to the trust. None. They hadn't even been advised on how to do it. That's not okay. Okay, that's not okay if you're getting charged a ton of money. Okay, and then there's us. Right? We do things differently. We are absolute nerds for our clients, but in the best way possible, because you don't want somebody that knows a subject just barely, or that the only incentive is to keep charging you by the hour to work on your plan. You want somebody that loves what they do and are going to be careful about it. I make sure that we assess family dynamics, that we address things like disability, somebody aging. What stage of your life are you? Are you in retirement? Are you still in the growth stage of your life? How are your assets currently titled? I look at those risks. I tell you about those risks. I advise about those risks. I help you know how to implement your plan. And guess what? We also have trainings for people that you appoint to these roles. No other place has these types of trainings available for the people that you appoint to the roles. Because guess what? They're not born, we're not born with manuals that say, okay, here's how you're going to be a power of attorney agent for this person. That doesn't exist. So it's incredibly, incredibly useful to have these resources at their disposition. We recently, for example, just published our legacy planning handbook, which has even like questions to ask between agents and then questions for you to ask your agents. Is awesome. I love it. Okay. And we're just about to publish the Spanish version too. But in addition to that, taxes. We help you plan tax-wise. I have a master's of law in taxation, meaning I am a hyper nerd in numbers. You don't often see that with lawyers. Most lawyers have this joke of like, they're afraid of mathematics. I love mathematics. I taught math at the college level and college physics. So I'm a huge math nerd. But it's important for you to understand the tax consequences because it's not just about the estate tax, okay? It's not just about that. So we have the system. Yeah, we're super organized and it's based on the use AAA. And it's my homage to AAA because they saved my butt so many times in college, like when a tire popped or when I ran out of gas, all those things, those mistakes you make when you're in college. But it's about updates, okay? We need to remind you, our job, right, is to get you involved in updating your plan, making sure that nothing's missing, especially if you acquire new assets, get rid of things, and so forth. Strategy, because guess what? Everybody's family is different, okay? I've had families where they are the most adorable 4 kids, 2 parents, they get along so well that they still have dinner every Sunday together, even though they're all adults. Beautiful. And then I have people that are like, I cannot have anybody in my family. Like I can't have my parents, my siblings, nothing. I have no contact with them whatsoever. And so these are involved very different strategies, right? Education, you need to understand how things work. This is why our design meetings with clients are hours long, okay? And they're broken down into different sections, but it is a very long time that I spend with clients because I want you educated about your choices. Advice, obviously, right? It's our job as counselors to tell you the consequences of choosing different things. And then it's up to you to decide, but you're making an educated decision at that point. Accountability, okay? As we call it in our team, we lovingly nag our clients to do the part that they need to do to make their plan effective. And awareness because there's changes in the law, there's changes in tax law, there's changes in Florida law, there's changes in federal, all these things can affect them and their plan and the strategy that they chose. So we want to make sure our clients stay on point. And how do we do that? Because our clients are ours for 3 years minimum. Okay. Some people can say, well, I have a trust, right? And then tell me, put a 3 in the chat if somebody has talked to you about a trust. I have so many people that are like, oh yeah, we had one today call, I would like a Rockefeller waterfall trust. And I had to laugh because these are just branding names for very standard irrevocable trust instruments used in the insurance industry. But trusts are kind of like brought up along. So if anybody has talked to you about a trust, put a 3 in it. Okay. I want you to understand a trust itself is not a plan. Okay. If a trust instrument has mistakes, it's going to be very painful. If a trust instrument is not funded, you're going to have an expensive paperweight because trusts don't even exist if they don't have assets. If you have a trust, but it was done DIY, they can be challenged so quickly in court. And if it's a basic trust, a downloaded form or something provided by a financial advisor, they usually lack the protection against lawsuits, against divorce, against young individuals. They don't have a lot of what I call bumpers written in and built in to protect family members. So a trust alone is not a plan. Okay, cheap plans. Cheap plans cost money. Cheap plans destroy tax benefits. Remember, right? Doing that joint tenancy with right of survivorship. Well, guess what? Now you go and sell the house. You don't get all the capital gains exclusion benefits that you would have had this other person not been entitled with you. That's a big loss to have when it's your primary residence. You don't want your children probably ending up in foster care, but that is the reality of forgetting to address guardianship of children. And people that you don't want there will raise their hands. And let me ask you, for those of you with siblings, okay, put a 3 in the chat if you've had an argument with your sibling in the past 3 years. Now, I'm an only child. I am both fortunate and unfortunate in that regard, but I have most certainly had a very large percentage of my clients tell me that they have at least one sibling that they don't get along with, they don't talk anymore, something happened. These dynamic issues that are real, I want you to be cognizant of, okay? So your life doesn't stop because you wanted to go the cheap route. It doesn't all of a sudden become this wonderful rose-colored glasses world. It doesn't change. And as we say in Spanish, lo barato sale caro, okay? Cheap is expensive. There's an important aspect of having a tax-trained lawyer, and that is every estate, every trust will have income tax consequences. Yeah, very few law firms are going to talk to you about the income tax consequences because they just don't know. This isn't something that's discussed. They don't get this training. This isn't part of regular law school. This is part of having a master's of law and taxation program where you get deep into the nuances of income tax issues. And if you do not know how to properly plan to minimize those income tax consequences, your family's going to end up having a lot less than you thought, even if you had the plan, okay? This is what the legacy planning session looks like in case you're interested. So if you qualify, then it's a 90-minute session with me. You can ask my team. I tend to go over. It's one-on-one. Okay, so it's a lawyer with you in a confidential setting. I review your assets, those risk factors, the family dynamics, the legal gaps. I learn all about you because I need to properly advise. And I talk to you about all those fun tax secrets that other planners just, they don't know, right? They don't know what they don't know. All right, so this is that golden ticket again. If you're interested, you can do the little QR thing. Julie can put the little code on the side. Remember, not all of you are going to qualify. That's okay. All right. But you can scan the QR code. It's a 15-minute call. We do end it at midnight. Okay. So this opportunity to have that conversation and book you for a legacy planning session for less than what I usually charge will end tonight. So that's why if you want it, then go ahead and go on the QR code. All right. Finally, I wanted to address the 3 myths that every family I've seen it along the years. Oh, estate planning is only for rich people. And okay, sure, when Prince died and he had like a $40 million estate upon his passing and died without a single estate plan, maybe his family was okay with having to punch out $10 million to address the problems left behind. However, your family probably does not have this at disposition because most of us are, middle-class families, right? And so it is so much more valuable for us to plan because the rest of our loved ones simply do not have that kind of access. They simply do not have the level of money required to open up probate proceedings or to open up guardianship proceedings. The next one is, oh, my spouse gets everything automatically. We're all so good. That's false. Okay. I was retained by a gentleman about a year and a half ago, and he was so sweet, so kind. He had been represented by another lawyer in his wife's probate proceedings for a year before then, but things were not working out. Nothing was moving along, and so he retained me. I filed an emergency motion because this man was had serious cancer and needed to access the one asset, the big asset, the house. It needed to be sold so he could pay for his care for his cancer. His wife also died of cancer. It was tragic. And I got an emergency hearing within, a week of being retained. It got set for another emergency thing to be determined a couple weeks later. But 2 weeks after being retained, my client died. And the daughter got everything, not his daughter. He'd been married for 35 years, but because of the way the law is set up, when you don't plan, she got everything. And he had absolutely no recourse, no resources during a time that he really needed important treatment. So the other myth, right, is, oh, I can't afford this now. But these are little lies we tell ourselves, okay? If we want something, we budget for it. If we want a house, okay, we might not have $400,000 available in our pocket right now, but we plan for it, right? We say, okay, this is going to be, we get my financial statements, I can pay this much per month, and so forth. Same thing if you want a car, same thing if you want to open up a business. What I can tell you is that planning, with us at least, is usually less than 1/10 of the state's plan for you, okay? Which is life-saving for family members. It's life-saving for you because somebody gets quick access to take care of you. It's life-saving for them because they don't have to be out of pocket like crazy. That's the golden ticket. Again, if you wanted to see the QR code, if you want to know if you can qualify for that legacy planning session, again, not all of you will. That's okay. That's okay. We're not the total fit for everybody. I don't want that to be the case. You need to go see specialists, right? Doctors of law. But it's available there for you.